Part 2. International Military Tribunal at Nuremberg. Road to the IMT. At the end of World War II, 55 million were dead, and an entire continent was in rubble. There was agreement that those who brought about this destruction should be punished. The question was how. In January 1942, members of the 9 occupied countries in Europe sitting as governments in exile issued the St. James Proclamation, which said at the end of the war, those responsible for war crimes should be punished. And then in 1943, in October, Churchill from the UK, Roosevelt from the US, and Stalin from the Soviet Union issued the Moscow Declaration Statement of Atrocities, promising that the major war criminals will be punished by a joint decision of the governments of the Allies, and also that the Allies would return accused Germans for trial by the country in which the atrocities were committed. But in general, there was a lack of consensus amongst the US, UK, and Soviet Union as to what to do with the perpetrators of these crimes. In the US's view, initially, it was that Germans should be summarily executed. This was the view of Henry Morgenthau, President Roosevelt, Secretary of the Treasury, who wanted to summarily execute 2,500 top Nazi officials as part of his plan to pasteurize and strip Germany of its industrial capacity so that it could never again in the future wage war. Morgenthau's foil was Henry Stimson, who was President Roosevelt's Secretary of War. Stimson wanted a legal approach. He wanted trials. And in the end, this legalism won out. But public opinion in the US still trended towards shooting or executing Nazi officials. The problem after World War II is that people were too interested in punishing war criminals, whereas today, if you look at the ad hoc tribunals or who's being brought or not being brought to the ICC, today the world really isn't interested in punishing war criminals. So it's interesting to kind of look at that difference in perspective from the end of World War II to the present day. For the US, it was going to put on trial the starting of an illegal war. And to the US, the Holocaust was initially, at least at the IMT, a secondary issue. To the UK only agreed to trials after first the US wouldn't budge about summary executions, and then also the Brits were outraged when it came to light that Stalin was really interested in executing 50,000 or 100,000 Germans. There was tremendous public pressure in the UK to punish Germans because the Brits, as a people and a country, were so deeply affected by World War II. The Brits were putting on trial at the IMT their own suffering. And finally, the Soviet view. Stalin really wanted, as we mentioned, to execute people, and he said so at the Tehran summit. He gave a figure. He had a really punitive attitude towards Germany. It was, for the Soviets, more of a punitive gesture. In May 1945, at a UN conference in San Francisco, there was an agreement reached by foreign ministers of the 4 allied countries, so we bring in France to the fold now, for an international military tribunal for top Nazi officials to be tried, and where it would be independently determined the whole question of each defendant's guilt or innocence based upon evidence and the law. So, right, legal-based decision. And the next month, in June 1945, was the London Conference, where the war's victors met in London and essentially decided to call the tribunal the International Military Tribunal. At the conference was U.S. Supreme Court Judge Robert Jackson, who was offered the position of chief prosecutor at the IMT. He was the only U.S. Supreme Court justice to ever take a leave of absence from the court and then later to return. It was decided the prosecutors and the lawyers would be from the 4 allied powers only, and that there would be 8 judges, 1 primary and 1 alternate from each country. It was also at the conference in London where the IMT charter was drafted, and we'll have a look at that in just a minute. What was the IMT? In June 1945, the Allied powers met in London to establish the contours of a tribunal that would hear evidence and pass judgment on Nazi officials who had allegedly committed atrocities during World War II. At the time of the conference, the tribunal was also given a name, the IMT, International Military Tribunal. It was to be the first court ever created by international agreement of the United Nations being the countries that banded together during World War II to fight the Axis powers, and not the United Nations supranational organization that we think of it as today. I suppose cynically this would be where one could argue that this is the genesis of where the victors of this armed conflict decided to sit in judgment on the vanquished, but the legacy of Nuremberg deserves a much more positive reflection than that. The judges at Nuremberg were going to be called upon to prosecute international offenses on behalf of not only the states to which they belong, right, but also others, all other states, the United Nations. It wasn't just about justice for the four Allied powers in principle. Nuremberg was conceived and can only really be understood as a revolutionary event in the development of international law. With the IMT Charter and with the judgment at Nuremberg, international law was now binding on the individual. And this opinion, this view and understanding is really also confirmed in something that General Telford Taylor, the U.S. Chief Counsel for War Crimes under Control Council Law Number 10, which we'll discuss in the last part of class, and who also was involved with the prosecution at Nuremberg, when he was asked about the major significance of Nuremberg, he said that it was those portions of the judgment dealing with the area of personal responsibility for international law crimes. So that's, the crowning achievement and legacy of Nuremberg. The tribunal was also, in addition to meting out personal responsibility in international law for individuals, was also created in the mind of reconstruction of society. Now we'll look at certain particulars of the tribunal statistics and particular information about the defendants in just a little bit. I'd like you all to take a well-deserved break from listening to my voice for a little bit and watch the documentary that's linked on this page, The Nuremberg Trials. It was a documentary put together by PBS in 2006. And even if you've seen a number of Nuremberg documentaries, I'd like you to watch this one again and look at it and think particularly about legal features of the trial. For example, what did each of the Allied powers envision for justice after World War II? What fair trial protections were put into place with the Nuremberg Charter? What were some of the more persuasive ways of introducing evidence at the trial? And how was the courtroom, for example, altered to both facilitate a trial of multiple defendants and also bring the trial to the watchful eyes of the world? We'll catch up on the other side of this film. Welcome back. I hope you've had the opportunity to look at the documentary on the Nuremberg trials with more of a legal perspective than you would have previously. Let's now look at the legality of the creation of the IMT. Never before, as you heard in the documentary, had this type of international tribunal been attempted, because under classic public international law, military tribunals, or courts of occupation, were allowed under the laws of war to try criminals. So here are the victors, who were also the occupiers, who were also the Allied powers, were exercising their joint collective right to try the Nazi leadership. But this was the first court to apply the law of the IMT Charter plus use customary international law to prosecute and punish international crimes. The IMT Charter was assigned as part of your reading for the week, and I encourage you to go back and look at it again. It's not very long, it's very simply written, but it clearly sets out what the IMT is going to do, what types of crimes it has jurisdiction over, what defenses are not allowed, what are some of the fair trial protections listed, and these types of disclosures or information included is really important to have been included in the charter, because there was a real stress on making this outwardly seem to be a very a fair trial process with due process, because military tribunals are typically not considered as being very demanding of fair trial and due process standards as in civilian courts. So it was important to sort of list out ahead of time what these fair trial protections and crimes to be prosecuted and defenses that aren't going to be allowed, what all of those are going to be.